I'm going to talk about allocation for trial, sometimes known as mode of trial. The legislation is at Section 20 of the Magistrates' Courts Act 1980. Criminal law cases can be divided into three. The least serious are called summary-only offences, and they can only be heard at the Magistrates' Court. The most serious are called indictable-only cases, and these can only be heard at the Crown Court. And in between are either-way offences. These can be heard either at the Magistrates' Court or the Crown Court. So to take as an example, assault. Common assault is a summary-only offence. It can only be heard in the Magistrates' Court, and the maximum sentence for a single offence of common assault that the magistrates can give is 6 months custody. Section 18, grievous bodily harm, wounding, can only be heard at the Crown Court. It is an indictable only offence. That means the magistrates cannot hear the case, it has to be heard at the Crown Court. And in between is actual bodily harm under Section 47 of the Offences Against the Person Act and Section 20, grievous bodily harm of the same Act. So to take actual bodily harm as an example, it can be heard either at the Magistrates' Court or at the Crown Court. If an individual is charged with actual bodily harm, they will first of all go to the Magistrates' Court. At the Magistrates' Court, they will be invited to enter a plea. If they plead guilty, then the Magistrates' Court will either sentence them in the Magistrates' Court or send the defendant to the Crown Court for sentencing. However, in the event that the defendant pleads not guilty, the matter will then proceed to allocation. At allocation, the prosecution will indicate where the prosecution, considers the matter should be tried, either at the Magistrates' Court or at the Crown Court. And then the defence will say where the defence considers the matter should be tried, either at the Magistrates' Court or at the Crown Court. And then the magistrates will decide where they consider the matter could be dealt with. So it may be that having considered the evidence, the magistrates conclude that the case is too serious and they will then send the matter to be tried to the Crown Court. However, the magistrates may decide that the case is within their jurisdiction and may decide that the case could be heard within the Magistrates' Court. At that point, the defendant is then given the option, should they wish, to be tried at the Crown Court. So that is mode of trial. If the defendant pleads not guilty to an either-way offence, and if the magistrates decide that the case is eligible to be heard at the Magistrates' Court, then the defendant has the final say as to whether or not they wish the trial to be heard in the Magistrates' Court or whether they wish to elect for the matter to go to Crown Court. There are perceived advantages and disadvantages of a trial in the Magistrates' Court and perceived disadvantages and advantages of a trial in the Crown Court. Magistrates' Court may be perceived to be cheaper, quicker and less formal. However, a Magistrates' Court may be perceived to be less likely to result in an acquittal for the defendant. At the Crown Court, the matter is perceived to be more formal, with magistrates, with the judge and lawyers wearing wigs and gowns. However, the matter of whether the defendant is guilty or not guilty is determined by a jury, by 12 lay members of the public, and there is a perception that 12 lay members of the public may be more likely to return a verdict of not guilty than guilty. So there are advantages and disadvantages of trial at the Magistrates' Court and the Crown Court.